Hi everyone, I'm David Fisher, and this is Presidential Perspectives, where we take a look at current events through the lens of American history as seen through the lives of the presidents of the United States. In this episode, we focus on the history of impeaching federal judges. Elon Musk, the head of President Donald Trump's new Department of Government Efficiency, had some relatively bold statements recently about federal judges, initially focusing on Paul Engelmeyer, a district judge from the Southern District of New York, who issued a temporary injunction against Musk's Doge operation and their access to a Treasury Department IT system. Musk calling Engelmeyer a corrupt judge protecting corruption. He needs to be impeached now. A couple days later, Musk went even further, a broader call in which he said there needs to be an immediate wave of judicial impeachments, not just one. So we thought we'd take a look at the history of impeachments for federal judges, which has been very rare in American history, and there's been only one case in all of American history in which a president pursued impeachment of a federal judge for political or policy differences. That case goes back over 200 years. We'll talk about it in just a moment. Let's start, though, with the rules. What does the Constitution say about impeachments for federal judges? Well, it covered it actually in two places in the Constitution. First is the impeachment clause in Article 2, Section 4, which is about impeachment for all federal office holders, including judges, and it says the president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. But there's another clause as well. This is in Article 3 about the judiciary, Section 1, which says that judges shall hold their offices during good behavior. So according to the Constitution, you've got bribery, treason, high crimes, high misdemeanors, and for judges, this notion of good behavior, which isn't really defined, but those would be the reasons potentially to impeach and remove a federal judge. So let's go back to that case at the very beginning where the boundaries around these definitions actually were tested in a very specific case. We go to the third president of the United States, Thomas Jefferson. He was kind of perturbed about judges from the very beginning, including some animosity toward his predecessor, John Adams, who had placed John Marshall, one of the political rivals of Jefferson, not only on the court, but as Chief Justice. And then Adams appointed 19 federal judges, all Federalist-leaning federal judges, right at the end of his term, because Congress created the appeals court. That whole structure went into place at the end of Adams's term. He filled them all with Federalist-leaning judges, and Thomas Jefferson wasn't very happy about this, kind of a burr in his saddle as he confessed to Abigail Adams, John Adams' wife, in a letter that he wrote in 1804. I can say with truth that one act of Mr. Adams' life, and one only, ever gave me a moment's personal displeasure. I did consider his last appointments to office as personally unkind. They were from among my most ardent political enemies, from whom no faithful cooperation could ever be expected, and laid me under the embarrassment of acting through men whose views were to defeat mine or to encounter the odium of putting others in their places. It seemed but common justice to leave a successor free to act by instruments of his own choice. Not happy with those decisions, not happy with all these Federalist-leaning judges. Well, President Jefferson decided to kind of go after one of the sitting justices on the Supreme Court, Associate Justice Samuel Chase. He thought his behavior on the bench was partisan. And particularly there was a grand jury instance in which Chase made some comments that, again, were believed to be beyond the pale, overly partisan, perhaps seditious in nature, and Jefferson thought, this can't stand. We have to make an example. Let's go after it. So he wrote a letter to Maryland Congressman Joseph Nicholson, urging him to pursue this possibility of impeachment. According to Jefferson, ought this seditious and official attack on the principles of our Constitution and on the pleadings of a state to go unpunished, these being the actions of Justice Chase? Well, Nicholson decided to go forward with Jefferson's recommendation to pursue impeachment. He joined common cause with John Randolph of Virginia, and they moved forward with that position in the House, and it passed overwhelmingly. In fact, the vote in the House for impeachment, 73 to 32. Now, admittedly, that was almost entirely along party lines. There were 8 articles of impeachment that were laid into this charge, which then moved over to the Senate for the actual trial. And again, the main topic here in the trial is, were Chase's actions such that they violated the clauses in the Constitution that would rise to the level of impeachment and removal. High crime, high misdemeanor, violation of that good behavior clause. Well, Chase obviously felt no, and he had a written response to those charges that were read at his trial in the U.S. Senate. According to Chase, a party in power under this pretext might destroy any judge who might happen to say something capable of being construed by them into a political opinion adverse to their own system, obviously warning that that would be a terrible precedent to set. One of his defense attorneys, Luther Martin, spoke about Chase's comment at the end of his summation. He called Chase's comments rather a violation of the principles of politeness than of the principles of law, rather the want of decorum than the commission of a high crime and misdemeanor. Again, trying to draw that distinction between sort of the free speech element and policy perhaps differences from something that would be a high crime, high misdemeanor, or the issue of the good behavior. Well, the Senate decided to go in favor of Chase. They did not get the 2/3 required for removal on any of the 8 articles. Chase remained on the bench, in fact, until he died in 1811. Now, many consider this a very important precedent, emphasized nearly 200 years later by Chief Justice William Rehnquist. He said that as a result of this case about Chase, judicial acts, their rulings from the bench, would not be a basis for removal from office by impeachment and conviction. He called this specific result enormously important in securing the kind of judicial independence contemplated by the Constitution. Again, setting a precedent. Chase has been the only Supreme Court justice ever impeached, the only federal judge ever impeached for partisan policy reasons, again, dating back to this very important precedent. In over 230 years, under the operation of the Constitution, Chase is one of 15 federal judges who have been impeached. 8 were then convicted and removed. 3 others resigned before their case would go to trial in the Senate. So a total of 11 federal judges have basically been removed because of this process. So what were the reasons if it wasn't for policy or partisan differences? Well, 4 were related to perjury or taking a bribe. 1 was based on abuse of power. 2 were for favoritism or improper business relations with the litigant. 1 was for being, or rather 2 were for personal activities such as being intoxicated on the bench. 1 was for waging war against the United States. That was a judge in Tennessee during the Civil War. And 1 was for income tax evasion. Those were the 11. None other than Chase back in 1804 had ever been charged, let alone convicted, for partisan or policy-related activities in the impeachment process of a federal judge. That's the full history. That's the history of impeaching federal judges in the United States. For more on some of these stories, you can check out my books on Amazon.com. You can also subscribe to this YouTube channel. Until next time, I'm David Fisher. This is Presidential Perspectives from Presidential Chronicles.